Have a seat. Make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be requested with judicial bias and due process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
Well, it's covering all the judicial bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have a mistake straight me telling you didn't give a shit about what I had to say.
Okay, hold on. Listen, Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers Judge King Green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear? Is that clear?
She gets me this entire time. No one has made her answer that.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, definitely means you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of...
Welcome back, because today's hearing is a masterclass in why sovereign citizen logic implodes the moment it meets a judge who actually runs their courtroom. This is the long-awaited return of a repeat offender, someone who didn't learn the first time, didn't listen the second time, and is about to discover that courtroom patience is a limited resource. On one side, you've got Judge Oakley, calm, direct, and completely unimpressed by pseudo-legal word salads. On the other, a self-represented defendant convinced that disagreement equals corruption and rulings he doesn't like simply don't count. This case isn't about obscure statutes or secret loopholes, it's about control. Who runs the courtroom? Who decides what matters? And how fast does arrogance turn into contempt? Stick around, because what starts as procedural bickering snowballs into fines, warnings, and a slow, painful unraveling.
An unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making...
What statement is that?
It was
I thought we were talking about Judge Green's SOS statement.
When you made this statement that you were setting aside my regular trial, saying that you saying that the prosecutor, the township, and his court all see things the same way, setting it aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my way and setting it aside on what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt anytime I tried.
I am threatening you with contempt. No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me, is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me, because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of.
Right here is where the power struggle begins. The judge gives him a gift, choice. Pick your motion, take control of your argument, keep things focused. And instead of answering the question, he launches into explanations no one asked for. Judges don't ask open-ended questions for fun, they're managing time, jurors, and procedure. When a judge says yes or no, they mean it. This is also a classic sovereign citizen move, overwhelm the court with volume instead of relevance. But notice Judge Oakley's response, calm, direct, corrective. No theatrics. No ego. Just, answer the question. This is the defendant's first chance to show he understands how court works.
Again, you're trying to spin the stereotype.
I'm not spinning.
Based on you not allowing me to do it. And that's what you told me when you addressed me.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once permitted. It's on the why it's on the prosecutor to prove those things. There's the false course of irregularities.
All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking question on shows exactly that there is enough to show. You're supposed you need to keep shit.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
Go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
I'll put on record that if whatever you would like to do from there, you can, because I won't until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
We arrested Mr. Crusoe while he was in Huron Township. The Beaufort District Court has jurisdiction over offenses that occur within the township, both civil and criminal.
Did you appeal Judge Green's decision on that motion?
I'm prosecuting because I'm actually been contacting the appeals.
Okay, so there's no appeal filed yet, correct? I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
And there it is, the moment sovereign logic always detonates. The bias accusation. This is the shortcut argument: if you don't agree with me, you must be corrupt. Courts hear this constantly, and judges hate it for one simple reason: it misunderstands the job entirely. Judges aren't referees making both sides happy, they're decision makers. Someone always loses. When the defendant accuses the judge of collusion just because she agrees with the prosecutor, he's not exposing corruption, he's exposing how little he understands about adjudication. And Judge Oakley doesn't just shut it down, she explains it. That's patience.
Keep arguing that same motion.
All she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And I have all the recordings and were submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, the judge said that.
Fine, then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay. Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant, because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So, that's two motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right, do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen, the thing is what
Mr. Crucell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because
This is where the tone shifts from instructional to disciplinary. Judges don't threaten contempt casually, it's a last resort tool to restore order. And notice how clear the warning is: interrupt again, and it's contempt. No ambiguity. No guessing. The defendant responds by interrupting again. And this is where viewers should pause and ask themselves, what outcome does he think this leads to? Because contempt isn't about hurt feelings, it's about preserving the authority of the court. Once fines start stacking, the judge isn't negotiating anymore. She's documenting. And documentation is
You want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay.
Prosecutors.
Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Motion for judicial notice. What does that judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used.
Okay. For example.
You use motor vehicle.
Okay. Motor vehicles pretty much.
This exchange is devastating, and not because the judge is mean, but because she forces logic into the open. If agreeing with one side equals collusion, then agreeing with you would also be collusion. The defendant walks straight into that trap and can't escape it without contradicting himself. That's why judges ask yes or no questions. And watch how fast the contempt fines jump. That's intentional. Courts escalate consequences when warnings fail. This isn't about $100 or $200.